Please rise. Justices of the Appellate Division, Supreme Court, First Department. He who wishes to have visit from the appellate. Draw near, give your attendance, and you shall be heard.
Welcome to the Appellate Division. We have over 4 hours of argument time requested today, so I ask that you ask for the time that you need, not what you might want, with the understanding that we have read all your briefs in the record and we are familiar with the case. People versus Hayward, appellant?
Yes, appellant requests 6.
Respondent? 6, 2, and 6. Duval versus Centralite is adjourned. Mia versus Pipe Dreams Realty, appellant? I'm sorry, you appellant? Okay, how much time are you requesting? 5 and 4. People versus Clark is submitted. Fundus versus Scarola, appellant? There's 2 respondents in this case. You don't have a cross appeal, though. Okay. And the other appellant? Not here? Okay. 6, 1, and 6. Imbert versus New York State Public Employment, appellant? I'm sorry, what?
I would request as much as possible and perhaps a few minutes for rebuttal. I have 3 worthy adversaries who I'm sure have a lot to say.
Okay. I know there's 3 respondents. Is everybody here?
2 of us are, Your Honor. I don't see it.
Okay. Go ahead.
United Federation of Teachers, 5 and 10.
Okay, I will give 5, 2, 5, and 5. Shivers versus City Smiles Dental, and Justice Pitt is recused. Appellant? I'm sorry, how much?
8 and 3.
And who are you here for? 5, 2, 5, 2, and 5. People versus Stokes is submitted. People versus Bracero, appellant?
4, 1,
Respondent? 4, 1, and 4. Gaines versus City of New York, and Justice Kennedy is recused. Appellant? Nobody sees on that? Okay, it's submitted. Hutcher versus Madison Square Garden, appellant? Okay, I will give 8 and 2 and 6 and 2. And 508th Avenue is submitted. So the first case is People versus Hayward.
Yes, good afternoon, Your Honors, and may it please the Court, John Vang for Vincent Hayward. I'd like to talk about 2 points today, but the first point is the suppression issue. The people failed to meet their burden of going forward at the suppression hearing. The officers seized Mr. Hayward based on his supposed likeness to a wanted poster. The problem is that there was no evidence that any of the complainants had identified the man in the poster as their assailant. While the people argue that Mr. Hayward matched the descriptions of one of the complainants, there was no evidence that any any of the three officers had the complainant's descriptions at the time that they stopped Mr. Hayward.
Well,
As the
what was
court
wrong
knows,
with them using the poster as their identification?
well, there would be no problem with using the poster as identification, but the people had to submit very important evidence here, which is that that the poster, in fact, displayed the perpetrator. There's no evidence here at all about, how the evidence, how the video was taken, which complainant's building the video was taken from, the date or time of the video. None of that was put forth at the suppression hearing. All you had was a wanted poster. There's a huge...
Why isn't that an issue to be argued at trial in terms of weight of evidence? I mean, here we have a poster that's identifying someone. Someone can look at it and stop people who they think might resemble that person, right?
Defense counsel raised that argument below, Your Honor, and the court didn't address it. Defense counsel argued that no one of the complainants had identified the individual in the wanted poster as her assailant. She put forward that argument to the court, but the court didn't address the issue. It's an essential part of the suppression analysis that the people have to justify the stop at every step. That includes the people putting forward evidence justifying the basis for the police's stop. The basis for the stop here was the wanted poster. But without evidence establishing this very crucial evidence connecting the dots that the person in the wanted poster was in fact the perpetrator, the people don't meet their burden of going forward, of proving the legality of the stop to begin with.
I like to go back because I was under the impression, I believe it was Lamboy and Ruiz, they observed the defendant. He matched the description close enough that was provided by one of the complainants, and certainly he resembled the person in the photo, but the fact that he was in the area where these offenses took place around the same time that, and I'm talking about the time of the night.
Yeah.
It was like 1 a.m., something like that. So we have him in close proximity, right, to where these rapes occurred, the same time, like 1 in the morning, he matches the description. Why is that insufficient?
Just to clarify, Your Honor, there's no evidence that he matches the description.
It was close. It was close.
Your Honor, I actually have to disagree with Your Honor there. The basis for the stop was that he matched the wanted poster. There's no evidence that any of the complainants had actually spoken to any of these officers.
All right, so I'm going to tweak my question. I'll tweak it.
Sure.
In the same area, around the same time, and he closely resembled the person depicted in the wanted poster.
Well, Your Honor, there are innocent explanations for his being there, right? So this is the description is a man in Harlem that matched a clothing, a white T-shirt and a do-rag description. Well, there are innocent explanations for his being there. He was arrested and, he was stopped, seized right outside of his apartment. So he had an innocent explanation for being there. The fact that the police officers had actually stopped and frisked 14 people during the course of this investigation shows that any of these identifications, this information, was insufficient. It was actually imprecise.
Okay, so let move in just a little bit beyond the actual stop, and now we're in the stop, right? What was the issues while we were in the stop?
Well, first of all, the officers only had, even if you credit that this person matched the description, the officers at the outset only had a level 2, which means they only had a common law right to inquire. They only had a right to ask him questions. What they did immediately when they approached him was they engaged in a frisk. A frisk requires reasonable suspicion. So what the police were doing was that they were engaging in conduct that far exceeded any justification they had from the outset. So as a result of that, any of the DNA that was recovered, as well as any alleged consent, was a fruit of that illegality.
Does it matter that the officers would have been doing a protective frisk? Does that come into play at all?
That would be the case if the facts supported reasonable suspicion. But the facts did not support reasonable suspicion. In fact, the court ruled below, and this is the basis for the court's ruling, that There was only a common law right to inquire based on his likeness to the poster.
How
You
does
can
your
only-
argument play into the People v. Harris case that came from this court in 2017? Is it then now a level 3?
I'm sorry, I'm not familiar with the Harris case that you're referring to.
Well, I guess my question is just a little bit more pointed, right? So you have this person that they are claiming matches the identification of the wanted poster,
Right.
wearing similar clothing in the neighborhood. At that point, would they not have reasonable suspicion or?
No, and the court only ruled, Your Honor, that they had only a common law right to inquire at that point, so they did not have reasonable suspicion. I'll reserve my second point for rebuttal.
Thank you.
Good afternoon, Your Honors. Jeannie Campbell-Urban for the People. I have some things to say in response to the
Let me
arguments.
ask you before you start with that, though, why didn't this rise to a level 4 stop as opposed to a level 2 stop, based on what occurred here?
First, I would like to say that the suppression judge, Justice Swibel, found that the police officers had at least a common law right of inquiry. He didn't say only a common law right of
But he
inquiry.
didn't make a definitive determination one way or another about level 4. His reasoning was based on it being a level 2. So my question is, why wasn't it more than a level 2?
In terms of the level of intrusion that the officers imposed, because the officers, for the vast majority of the encounter, only spoke with the defendant and asked him non-confrontational questions that were geared towards investigating his reasons for being in the neighborhood,
But
which,
let me ask you this question, because this was his third encounter with the officers, correct?
correct, Your Honor, in this particular investigation,
Okay.
not putting aside anything that happened before.
In this particular investigation, this is the third time that they've come up to him. Why would he, at that point, believe that he would be free to leave or not to have to respond to their questions, especially when they approach him and frisk him immediately?
Because that's exactly what happened the other 2 times, Your Honor. And in fact, I think that the fact that the evidence at the hearing showed that the defendant had extremely similar encounters with police officers who were investigating this spree of sexual assaults, where he answered questions about what his name was, the fact that he lived in the neighborhood, and then was
Right, but
sent
that
on
would
his
matter
way.
on maybe a first encounter, but now we're up to a third encounter. At that point, doesn't somebody subjectively maybe think, well, maybe I am considered a suspect, and maybe there should have been Miranda and things of that nature?
Well, I'm happy to address the Miranda issue as well, but I'll just say quickly, the defendant was not in custody nor subject to interrogation. So I think the suppression court's ruling with respect to the defendant's statements is unassailable. I would argue that the 2 times the defendant was interacted with the police previously in this investigation, both of which occurred in very similar circumstances. He was in a public area near his home and briefly questioned, only could have reinforced for the defendant the idea that this was just a brief series of questions being asked by officers who were investigating, who were saturating the neighborhood looking for the perpetrator of these crimes, and were stopping a lot of people and asking questions about what they were doing there and where they lived. I would argue that all of those facts, all of which were adduced in detail before the suppression court, only buttress the suppression court's conclusion that the defendant was not seized, certainly not a level 4 encounter, and that I'm sorry, I'm losing my train of thought, that the police officers only subjected the defendant to a level 2 intrusion, ultimately.
What was your position about the frisk, why the frisk didn't raise the level of intrusion?
The frisk, as the evidence at the hearing showed, was a brief safety frisk conducted for the safety of the officers. That was the testimony at the hearing. It yielded no contraband whatsoever. And as soon as that was over, they stood a few feet away from the defendant on the sidewalk and had a conversation with him.
Were they permitted to undertake that frisk if the only justification was a DeBoer level 2?
Your Honor, we do cite a couple of cases in the brief that suggest that that's the case, where in circumstances where the officers believe for their own safety that that they need to frisk the defendant because he might be armed.
And what would be the justification for that here, that belief?
The fact that 3 of the rapes that the police were investigating were committed at knife point. The Officer Lambo, I would point out, also testified that the defendant's hands were in his pockets, which was his own personal explanation at the hearing for why he frisked the defendant.
That, he's now,
sorry?
they're considering him that he's a possible dangerous person, possibly this dangerous suspect. Why isn't it then a level 3 instead of this level 2 that the lower court found?
Well, the people's position is that the police had, in terms of their level of suspicion, had at least reasonable suspicion at the time that they saw the defendant before they even got out of the car. What we're also saying is that they did not, although they could have subjected the defendant to a level 3 intrusion at least, is that they didn't do that. In fact, it was only level 2. Even if this court disagrees with us on that issue and concludes because of the frisk that the entirety of the intrusion was at least a level 3, the police had reasonable suspicion here. As your honors have already mentioned, he matched the description in the wanted poster, and unlike what Mr. Vang said, Lieutenant Lamboy testified that he knew the descriptions that the victims had provided of the perpetrator and that he saw the defendant match those descriptions. So the defendant looks like the perpetrator. He's in the area, he's 1 block away from where the 5th incident occurred, and he's there at the time of night that the incidents occurred.
So then I guess my question would be, when they approach him and they frisk him and they're going to start asking him questions, at some point, they could have been more than just investigatory. They're asking him about a specific rape, being in the area.
A specific,
Rape,
Rape.
right? The rapes in the area.
No, they asked him if he was familiar with the rapes that had been occurring in the area.
Yes, the rapes in the area.
Right.
Why wouldn't that be more of a targeted question warranting Miranda?
It's not a question that is reasonably likely to elicit an incriminating response, Your Honor. I would also point out that the defendant was not in custody at the time. I have one more sentence to say, if you'll permit me, which is that even if the court concludes that the police acted unlawfully on the day that they stopped the defendant's DNA profile would have been inevitably discovered because he gave DNA in Virginia months before the stop occurred, and his DNA swab was sitting in the Virginia lab awaiting testing on the day that the stop occurred. Okay, thank you.
To the last point, Your Honor, inevitable discovery doesn't apply to primary evidence, and this was primary evidence, so the inevitable discovery doctrine doesn't apply here. But I wanted to talk about the indictment counts. All sub-2 counts of Penal Law 130-95.
Sorry, could you expand why doesn't it apply in this case, the inevitable discovery?
Well, because it's the primary evidence, it's the direct evidence that was recovered as a result of the police conduct in this case. The inevitable discovery doctrine only applies to evidence that is tertiary or secondary as a result of the evidence they obtained. It's like drugs. It's the very corpus of the evidence that the police recover as a result of their actions. Inevitable discovery doesn't apply to that. But I did want to talk about the indictment points. Under sub 2 of Penal Law 135, all of those counts need to be dismissed as jurisdictionally defective. As the court knows, there are 2 elements, the gravamen of the offense as well as an aggravating factor. Here, none of the sub 2 counts at all pled the aggravating factor, which requires a prior offense against a separate individual. The way it's charged now, the first element simply pleads.
Why wasn't it sufficient to track the statutory language?
It didn't track the statutory language, Your Honor. It didn't, no, because what they did is they inserted specific language, including that with respect to the gravamen offense, that it occurred with respect to an individual known to the grand jury, which means that's signifying that there's only one person identified in the count. The count under the aggravating element doesn't actually plead, that there is, a separate commission of offense against a separate individual known to the grand jury. That is
use the language one or more additional persons?
the use of the language one or more additional persons actually became superfluous in the way that this was actually charged.
Wasn't that language actually used?
The language is incorporated, Judge, but if you
So
look
why
at...
isn't that sufficient? Because that has to mean more than one person.
But the way that it's charged, Your Honor, what I have to point the court to is the way that it's charged right now is that the first clause The people actually simply describe the factual elements that make out the offense. And then the second clause, the people identify the crime that that factual element makes out. It only refers to one person, so it's insufficient. So the count should be dismissed. Thank you.
Mia versus Pipe Dreams Realty.
Good afternoon, Your Honors. Daniel Costello for Defendant Appellate. The law offices of Frank Polacco and Associates. Your Honors, this is a case which, the genesis of which is a fire in the Bronx in 2000.
We're familiar with the case. Why isn't this motion for summary judgment duplicative? It's fairly clear that in the last summary judgment motion, not only was the plaintiff's motion for summary judgment was denied, but your motion for summary judgment was denied on the ground that you failed to put forth sufficient prima facie evidence, which is exactly what occurred here. So why isn't this just a duplicative summary judgment motion that should be denied on the same exact ground?
So after 3 additional years of discovery and absolutely no evidence coming forward with regard to the cause of the accident, and with regard to the prior summary judgment motion, which said as a matter of law that there was no cause for the accident.
But the same decision also said that you failed to come forward with evidence that you were not negligent in causing the accident.
Well, we don't even get to.
Why did that change?
With all due respect, we don't even get to negligence because there's no determination of what the cause is. So if there's no
In fact, if you want to talk about that, let's talk about that. Why isn't the fire department finding sufficient to raise an issue as to whether it was what occurred in the apartment below and the landlord failing to provide heat and proper electrical systems that potentially caused the fire?
So
why aren't there issues of fact about that?
So the fire department report and the fire department marshal who testified, both of them say that the cause of the fire was not fully ascertainable. That's even if you want to listen to anything the report says, because when the fire department marshal testified, he said he couldn't tell which portions of the report he made and which portions of the report he got from other people. So the report would be, at best.
The fire department report is admissible.
Again, we would respectfully submit that it is not if you do not know where you got the information from. Just like in cases that we cited, the police report, if the police officer doesn't know where he got the information
And that
from.
goes to the weight of the evidence. When you're talking about if the fire marshal is testifying that report, he doesn't remember where he got the information from, that's up for the jury to weigh the evidence at that point, right? Because it's an admissible report.
I would respectfully disagree.
Okay.
Just like the police report is not, it's not the weight of the police report because there's hearsay in it. It's just not admissible from the get-go. And this.
Counsel, how did you meet your burden of showing, which it was your burden, it's your motion for summary judgment, that the building was in reasonably safe condition, including the heating system and the wirings in the building? How did you meet that burden?
Well, those were not, in the original complaint, what was alleged was that the fire was caused by the tenant who was downstairs in apartment 4H and a space heater. And as a matter of law, the law of the case, the first judge looking at that said, in fact, that the tenant in apartment 4H did not cause the fire. So these amendments that and this is.
The bill of particulars was amended to reflect that one of the causes of the fire, or the cause of the fire, was the electrical system in the building. And the lack of heat in the building, which caused the tenant to use the heater.
I'm sorry, Your Honor, are you talking about the proposed amendment of the bill of particulars?
Yes. Yes.
So the first bill of particulars was in 2010. The bill of particulars, which Your Honor references now, was in 2019. It's 11 years after the accident, the fire occurred, and 9 years after the original bill of particulars. And the case law indicates that there should be a reasonable excuse for the delay. There was no reasonable excuse for the delay.
Sir, the ultimate touchstone for whether leave to amend should be granted is prejudice, correct? I believe that's clear from the Kimso versus Gandhi decision from the Court of Appeals, as well as some prior Court of Appeals decisions, and I think Kimso also counsels that it's the party opposing the amendment that has the burden of establishing that it was prejudiced by the proposed amendment, and prejudice in this context means that you were hindered in your preparation or defense, not simply that you're exposed to more liability. So with that in mind, how is your defense of the action hindered by virtue of the late, albeit a very late amendment?
We were proffered that the time itself, the fire was in 2008. If the 2010 bill of particulars said what the later one said, we'd be within 2 years of the accident. We could speak to witnesses. One of the changes in the bill of particulars had to do with smoke detectors, and that was brought about because the fire marshal said, I think the report said there's no evidence of smoke detectors. So had that been brought to our attention in 2010, we would have had more than enough time to look to get witnesses. After 13 years, we would say that time itself was the prejudice.
If I may, Justice Kern, because the allegations, the theories of negligence, they were always based on, the failure to provide adequate heating and fire alarm systems. And so what we have here is the amended bill of particulars that really just set forth additional statutory violations, no new facts. So how are you prejudiced by that when you were always on notice about inadequate fire alarm and heating systems?
We would only say that, once again, the focus of the case for the first 9 years was always that the space heater had caused this fire. And all of a sudden, 12 years after the fire and 9 years after the bill of particulars, we get these allegations about fire alarms that maybe were there, maybe weren't there.
Thank you.
Thank you.
Good afternoon, Your Honor. My name is Durga Burtel, respondent, plaintiff's attorney, and may it please the court. Exactly, our brief addressed all the question court asked, exactly the point. The first point is the defendant failure to come forward and say he didn't do the negligence, so they would have showed the court, and then the judge, Rodriguez, the motion court, she clearly cited the First Department case and the Court of Appeal. I think that cites the Wingard, which is the moving party has to come forward with the evidence and then show that I didn't do the negligence, so therefore I should get as a matter of law.
What about the fact that you waited so long to amend your bill of particulars to add some of these allegations?
Yes, Your Honor, I'll address that point. Exactly the court asked the question before, and in our brief addressed that. In the complaint, clearly we said, the plaintiff says, failed to provide heating system, fire alarm system, fire exit stair, and other necessary safety devices to remain irregular, broken, so extra. So it's a complaint clearly states record 43 to 53. So that is clearly there, everything is there. And also, simultaneously, plaintiff's complaint alleges that defendant violated state courts, rules, and local regulation. And that was explanation of more when the plaintiff had an expert, and then after that, we had to amend that one. But it was just extension or maybe supplement. That's what we call, but the court says, yes, it's the motion court says there is no prejudice. And I want to address the court's point for the prejudice one. The defendants say it's a multiple dwelling building. There are more than hundreds complained before that in that building, and is the SPD record shows. And the defendant now comes after 13 years, he says, I didn't have a chance to investigate. What happened next day to investigate that building? What happened before that day as per the state statute and the regulation, New York City's regulation, they're supposed to have that investigation and have a record and produce this court or below court or
Well, sir, I think your friend's point is how he was relying on the allegations to orient the investigation. And so if they weren't on notice that there was a problem with a potential problem or absence of smoke detectors, they wouldn't know to investigate that that potential cause or contributing factor to the plaintiff's alleged damages.
A very good point, Your Honor, but is the defendant come forward with the court saying they investigated other things and they did not find anything, but we did not do that investigation? If there is a report, defendant is supposed to come forward that after this incident, these people, whoever the tenant living here, we are worried, we did the investigation, therefore we need to do it. So we did not do that part because plaintiff did not claim. So there is no allegation that. So the defendant prima facie failure to comply the state statute or regulation or the law that they're supposed to do it because the building is supposed to be habitable. And then another point, Your Honor, I just wanted to address that the first motion when we filed, there was no complete record of the fire department's record, and there was no deposition of the 4H. That's the immediately the fire where it started from the building. And we had a Bruce Wheeler. He testified that, yes, the statement I gave to the fire marshal is true statement. He testified. So we had an additional record now after the first, even the first motion. In the second motion, the defendant does not talk about either in the appeal or the second motion.
Thank you both very much.
Thank you, Your Honor.
The next case is Fundus versus Scarola.
Good afternoon, Your Honors. Anthony Genovese for Plaintiff Appellant Kenneth Fundus. There are three issues on this appeal. The first of which is that the lower court dismissed on the grounds that there was no established defect and that there was no notice. Principally, there are three parties opposing this appeal, the first of which is the owner of the property, M&M. The two others are the lessor.
What's your basis for liability against the defendants that are here with us today? Why is the owner responsible under your theory for this accident?
Well, the owner, M&M, the contention is that M&M did not submit any evidence in support of their motion for summary judgment, and it was nonetheless granted. They did not establish.
What's your claim as to why this accident occurred, and how are they responsible based on your claim of how this accident occurred? I mean, you're claiming it occurred because of the way the plywood was stored in the box. What did they have to do with that?
They allowed that to happen. This was a created.
What does that mean they allowed it to happen? What responsibility do they have for what was in a box and how things were stored?
The same responsibility as any of us have for what goes on in our own garage. This was a container that the defendants allowed to exist on their property.
But wasn't it how the things were stored in the box? Isn't your allegation that because the plywood was not stored correctly in the box and the way it was set up, isn't that a means and methods argument rather than a dangerous condition on the premises?
No, absolutely not. This is not a means and method. This is a trap that was set up by how these boards were stored in this trailer. The way they were stored, Your Honor, is if the trailer, someone went all the way into the back of the trailer and then from one side of the trailer to the other stored 8 by 4 foot plywood, 3/4 inch plywood sheets across the entire bottom. Then on top of that, another row completely across the trailer of 8 by 4 inch.
But did the owner store the plywood in the box?
Well,
what role did the owner have, or any of these defendants have that are here before us today, in how the plywood was organized in the box?
They allowed that condition to be created, knowing that it was there, knowing that they did not lease this container to anyone, but allowed people to use it, and thereafter ignored it. One of the characteristics of this entire case and the companion case that went with it is because this was a movie set, there was virtually no structure, organization, record keeping. There was nothing. People went just as they did, from Astoria Studios filming the movie over to the Yonkers soundstage, and when they got there, they were instructed to take 200 sheets of plywood that were stacked, as I mentioned. The only way to get that out, what the plaintiff did was pull out one board at a time on the left side and then squeeze to the back so he could push as someone else pulled these boards. What happened then is, as the expert Schneider said, there was a lateral load created because the plywood stored on top of the lower level of plywood created a lateral load, shifted the entire load, and crushed the plaintiff. And this was a trap. I mean, it's very easy how that should have been stored. It should be stored the way we see wood stored at any wood sales event, any box store, flat. It's stored flat, because that's not going to tip
Normally, sir, we hear
over.
the word trap, we think of some sort of passive, transient condition. Here, the plaintiff and his coworker were in the process of actively moving these plywood sheets when they fell, which I guess goes to Justice Kern's point, isn't this really a means and method? They were working with these materials at the time the accident occurred.
They were working with the materials, but it does not, transmogrify those facts into a means and method.
Well,
Because
I guess, counsel, I guess what we're all trying to ask is, what knowledge are you imputing onto these defendants that are here today? I understand you're saying that they allowed it to exist, but they would be akin to quote-unquote out-of-possession landlords. What knowledge are you attributing to them?
Look, the knowledge that they had was that this container was used by various individuals, and they never intervened. They never participated in what was.
This isn't like a sidewalk or a path or something on the surface that you think of as a dangerous condition. It was in a box.
Your Honor, neither would my garage fit that description. But if I let whoever I wanted to use it, and items were stored in there in a dangerous condition, there would be liability, because I have authorized that party to use it. In fact, I submit there was one entity, Greenwich Street Production, that was on that property at the time. There is no evidence in this record anywhere that any entity other than Greenwich Street Production had a container on that property. And that Greenwich Street Production testified that we don't lease those containers, we let people use them. So they let people use it. One of the owners said he hadn't been there 4 times in his whole life. The other one said that he was almost never there. So this is something that was allowed to be created because they let people use this device. And my point is, if that were the method by which these entities could escape liability, it would encourage quite the opposite of inspection. It would encourage people to ignore these sites, because I just let people use it, and I therefore stuck my head in the sand, and I didn't know what was in there. They didn't know because they didn't look, not
Sir,
because
do you
it wasn't
acknowledge
in there.
that they were out of possession landlords?
Absolutely not. What I'm saying is that, one of them contends they were out of possession. I submit all 3 of them are in possession. 1, because they retained rights of reentry. 2, because they actually Stop and Shop sent individuals there to check on the site, including the containers. And 3, obviously, Greenwich Street Production, because they ran that facility. And their testimony was not only that they didn't rent out that trailer, that they let people use it.
Thank you. Thank you very much.
Thank you, Your Honor.
Your Honors, may it please the Court, my name is Scott Perro from the Law Office of John J. Bello, Jr., representing the respondent in this matter, Greenwich Street Productions. I stand largely in concurrence with the arguments and the questioning. And
We're not making any arguments. We're the judges.
the line of questioning with respect to the appellant, I stand largely in concurrence with. The court below stands largely in concurrence with that, inasmuch as they have ruled on 2 issues that the appellant has brought forward, that A, there was no notice,
Counsel,
constructive
why
or
isn't
otherwise.
your client responsible for the way that the plywood was maintained in the box?
Precisely for the reasons that have been brought forth thus far. It was parties of the appellant who loaded the plywood into a container. They were working for 4 hours. And as I've been thinking about that, on the issue of constructive notice, we would, if you're imputing, which I believe the law is stated and the court below has stated is not, if you're imputing a duty upon us, more than an authority, a duty upon us of reasonable care, which I think we do, we would have had to unload that material, Mr. Paradiso, for 4 hours to reach the area.
But what about,
purportedly a defective
what about his argument that your client allowed this dangerous condition, as he put it, this trap, to exist on the property? Is there any basis in that?
In response to that, I would say, Your Honor, The dangerous condition, there was no dangerous condition inasmuch as there is no allegation in the record at bar that the structure itself, a container which was padlocked by a lessee of the premises, was dangerous. There is no allegation in the record that the plywood itself was a dangerous object. The issue is, was it stacked properly? The plaintiff appellant has come forward with no eyewitness testimony. In fact, if you read into the record, the only purported eyewitness to the occurrence listed by plaintiff, Joseph Damiano, has specifically in sworn deposition testimony in this matter refuted the concept that an accident even occurred. He was not a witness to the occurrence. The expert brought forward by the plaintiff has never gone to the location, has never photographed the condition. There's no empirical data to assert that there was a defective condition even existing. And I think these are the hallmarks of the underlying court decision, and that's why that decision should be upheld, summary judgment in favor of the respondents, Greenwich Street Productions.
Well, sir, going back to the threshold issue of duty, did the moving defendants have a duty to either inspect or otherwise maintain this container that was on there, on the leasehold?
The responding defendants, the lessees, Greenwich Street Productions, does indeed have a duty, Your Honor. That duty is to maintain their premises in a reasonably safe condition. I submit that the full record at bar has demonstrated that they did that indeed. We have never stayed away from the responsibility to maintain a premises in reasonably safe condition. However, this alleged condition with no empirical data, no photographic record, does not amount to a breach of that duty. I thank you, Your Honor.
Thank you.
Your Honor, I would just say in response that there is only evidence of a defect here. There is no evidence of the absence of any defect, and I'm baffled by the contention that the expert's testimony and the plaintiff's testimony together don't establish a defect. There was no testimony by Mr. Damiani that the accident did not occur. He simply said, I did not witness it. That's all he said. The trailer was not padlocked. This is a trailer that the defendant, Greenwich Street, testified we let people use. Okay, it's their responsibility to maintain that. They have every obligation to make sure that it doesn't contain wood that is stored in a way that can only be pulled out where someone is at risk of this lateral load crushing them, as what happened with the plaintiff here. All right, thank you, Your Honor.
Thank you. Imbert versus New York State Public Employment Relations Board.
Should I start, Your Honor?
Yes.
Good afternoon. My name is Gerald Crapell. I represent the appellant Claudia Imbert, who I think is watching this on YouTube now. This is an appeal from the decision and order of the Supreme Court Bronx County, which granted the respondents 3211 motion to dismiss Claudia Imbert's Article 78 petition. It's respectfully submitted that the decision in this case will affect any New York City public school teacher who, like Claudia Imbert, is injured returning from an out-of-school teaching assignment and applies for a line of duty injury.
What is irrational about the determination that if this injury occurred after she was done with her last assignment for the day and was on her way home, that that's not within the line of duty? What's irrational about that determination?
What's the last part? I'm a little hearing impaired, Your Honor. I have hearing aids.
That she was on her way home and had finished her last assignment and therefore was not within the line of duty. What is irrational about that determination?
Why is it in the line of duty, essentially, is the question.
Why is it irrational for them to find that it was not within the line of duty?
Why is it rational to find that it wasn't within the line of duty? Okay, well, there's a couple of reasons. First of all, She hadn't even begun the return trip home yet. She was assigned to teach a child in a housing project on East 174th Street in the Bronx. As she was going back to her car, before she even made it back to her car, she was struck by a vehicle making a left
Right, but it was
turn.
undisputed that she was done with work for the day.
Right.
She had finished her last assignment.
Okay. All right. So the Appellate Division, 3rd Department, has addressed this issue in teacher cases who were given outside teaching assignments and who were struck down, were involved in accidents on their return home.
Were those the same type of determinations, though, with line of duty injuries? I mean, was it the same factual scenario as the case that we have before us?
I would say it was the same factual scenario in both of these cases.
Same legal scenario, let me rephrase that. Was
Legal
it the
scenario.
Same legal scenario where it's a PERB determination that's being challenged.
All right. In both of these teacher cases, they were teachers who the workers' comp board.
Workers' comp board, this is not, that's the point I'm trying to ask you about. This is not a workers' comp case, it's
I
a
understand.
different type of case, so why are those cases on point with this case?
Okay, understood it's not workers' comp. But in both of those cases, workers' comp denied the teacher, you were not in the line of duty. You were off duty when you were going home. Matter of bump, off duty going home. Matter of arsenic, off duty going home. In this case, they say the very same thing. Off duty when you were going home. The Appellate Division has explicitly reversed workers' comp on both of those cases and
Are there
held.
any cases, though, that are these type of cases, PERB cases, where that determination has been reversed, as opposed to workers' comp cases? Did you find any cases in this scenario?
There are no PERB cases either way. There are no cases that hold that a teacher struck going home is not within the line of duty. There are no cases that hold that a public school teacher is within the line of duty. But the Appellate Division has rejected twice that off-duty rationale, that they have said, quote, that the return journey upon which she was injured would not have been taken except for an obligation of her employment.
Let me ask you one separate question. The determination that's being challenged now is the determination by the union, not to further grieve the determination of PERB. Even if PERB was wrong, why was it irrational for the union to decide not to proceed based on this scenario, which is a separate question?
All right, because the union, in deciding not to take her case to arbitration, this is a 15-year dues-paying union member with a serious physical injury. The union made several significant mistakes. They told Claudia, we are not able to overcome the driver's statement that you on your cell phone. That's the exact opposite of what the Board of Ed regs require. Claudia's statement, quote, shall be considered conclusive unless contradicted by objective and credible evidence, and the statement of a driver trying to avoid liability for knocking down a pedestrian in a crosswalk is not exactly objective and credible evidence.
Okay, and you have time for rebuttal.
Thank you, Your Honor. It's Michael Thomas Voice for the New York State Public Employment Relations Board. I would just like to begin by touching on something Counsel Krebel stated about this impacting Lodi determinations in the future for public school teachers. This case has zero impact on that question. That question was not addressed by the ALJ, by PERB, or the Supreme Court. The question of whether there was a Lodi was not before PERB. PERB presumed, because they were deciding a motion to dismiss, that the Lodi was meritorious. It even presumed that a good argument is made that the U of T might have been mistaken.
Right, but let me just ask this question in terms of their reliance or their presumption that the decision below by the U of T was made rationally. If in fact, a teacher is in between jobs, and maybe they're injured then, but then they go to another job, and that's their final job of the day. Presumably, they have to leave that job. They're not just going to magically disappear from that job. Why wouldn't that be something that would be considered still line of duty? I mean, it's not. It was 1 block away from where she had just left her final assignment.
It may very well be, and someone analyzing the load, I might conclude that. What we had to ask ourselves, Perb, is the opposite conclusion so outside the wide range of reasonableness to be a DFR, breach of duty of fair representation? In light of the fact that it's undisputed that similar cases have been handled that way by the Board of Ed. I'm not saying an arbitrator would agree by the Board of Ed, but it was undisputed that the Board of Ed has always takes the position that if it's your last assignment for the school day and you are past the sidewalk, it's not on school grounds.
But that's not what you had to address. You had a very narrow issue, and your issue was whether or not the UFT breached some duty to its member by not going to arbitration or not arbitrating her dispute. That's the only thing. You didn't have to deal with whether or not the Lodi decision was proper or not. That's not what was in your wheelhouse. Your wheelhouse was simply, did the UFT violate its own rules with respect to its member by not pursuing the arbitration that the member wanted the UFT to do?
Absolutely, Your Honor. Well, I was just pointing out that because we were giving the presumptions to the petitioner, we were saying this might not be perfect legal analysis. I would like to point out the Jordan case that was raised by Counsel Kreppel in his papers, in which the court was very clear that you can look at a union's action later on and basically say they could have done a better job, but that doesn't make it a DFR. At the time they were making the decision, were they within the realm of reasonableness? And Perb found that they were, so there was no DFR.
And what was the basis for the finding that UTF's determination not to pursue the grievance further had a rational basis?
It was multiple. First, they clearly they undertook a legal analysis. They just didn't ignore it. It wasn't perfunctory. The legal analysis was based on their experience handling similar cases. They were not presented any controlling legal authority going the opposite way. They were not presented any controlling legal other arbitrations going the opposite way. Their reading of the PMN at issue was on its face not irrational. It was consistent with the Board of Ed's past positions. These were all undisputed facts, which again, we weren't asking the question, would we, Perb, have gone to arbitration? Just was the union being reasonable? And with all these factors in the mix, we concluded that they were. And if
Thank
there's
you.
other questions, I'll...
Thank you very much. No, there's another side first. She goes first.
I'm sorry.
Good afternoon, Your Honors. May it please the Court, Ariana Dinellin for the United Federation of Teachers. It's respectfully submitted that the trial court's decision upholding Perb's dismissal of appellant's claim should be affirmed.
The bottom line is whether or not UFT breached its duty by telling the petitioner here, we're not going to proceed to arbitration on your claim because you're not going to be successful. And that's what the main complaint is, that the petitioner believes that that was a wrong determination that you made, right?
I agree with your thoughts in that regard, Your Honor.
I'm just trying to just strip it down to like essentially what the bottom line is here. And one of the points that the UFT took was that PM4, which is the rule or reg that's involved here, they made a very good analysis, and that is, this is almost akin to a situation where a teacher is finished from the school day and is walking across the street to the parked car and gets struck. That situation, that's not a line of duty situation because the school day is over. You're just walking across the street to your parked car to go home. exactly analogous to the situation that happened here, right? So that's why UFT, I think, took that position that you're not gonna, no matter what the facts are and everything, you can't change the simple fact that you were done for the day and you were going home.
That's correct, Your Honor, and the UFT used the facts as given to them by appellant, taking them as true, that she had finished her last assignment of the school day, that she was on her way home, and that she
And
was
even if she wasn't, even if she wasn't using a cell phone, let's just give her that.
Correct.
Okay?
Correct. That the UFT chose not to move forward with her grievance, taking it to arbitration because it had an objective and reasonable belief that it would be difficult to succeed in arbitration with her case, not because she was on or off her cell phone, but because she was not performing the duties of her position any longer.
Has DOE consistently taken that position that they are not going to give line of duty when someone has already finished their workday? Is that always the position? I know DOE is not here today, but is that the position they consistently take?
That's my understanding based on conversations with UFT representatives. It's not in our record, but the UFT, in analyzing the facts, did so with the knowledge. And these were grievance reps making this analysis, the folks that are in the trenches every day analyzing.
And in fact, even if UFT had taken that and arbitrated that and you would gotten an adverse finding, you're challenging that. How are you going to overturn an administrative tribunal's interpretation of their own rules? I mean, you got a tall mountain to climb in that situation, right? If the DOE actually takes that position, it's almost virtually impossible to reverse it on by the court.
To your point, Your Honor, the UFT did find that it would be difficult to succeed in arbitration because, again, they couldn't show that the appellant was performing the duties of her position at the time that she was.
Or even so, even if with that DOE's position in terms of PM4, their interpretation of that, how are you going to show that that's arbitrary and capricious, right?
Well, the UFT goes to battle all the time with DOE, and they don't see eye to eye, but, you know, some mountains are taller to climb than others, but in this case.
Some mountains are insurmountable, let's put it that way.
And in this case, they did have their own objective belief, and they documented their belief. They, in a timely, organized fashion, wrote to appellant more than once, conveying, this is why we don't think that we're going to be able to succeed. It wasn't arbitrary. It wasn't out of thin air. It was based on a rational interpretation of the facts.
Your decision not to pursue arbitration was not arbitrary, was not capricious.
That is my argument, Your Honor.
Got it.
If there are no other questions, I'm happy to sit down.
Thank you very much.
Thank you for your attention.
Your Honor, I would just point out a distinction between a teacher who goes to school and then leaves school at the end of the day, as opposed to a teacher who was sent on an outside teaching assignment. The appellate division has carved out an exception to somebody.
Counsel, if I may, really what you're arguing is like the merits of this line of duty claim, which is not before us. The issue is whether or not the decision below was arbitrary and capricious. But since you're talking about the third department, I like to talk about it because we know that they are workers' comp cases, but what I want to know is what, if any, discussion was there regarding the interpretation of on duty, because that's really what we have here. How is the term on duty interpreted as you know, as the PM4 and PERB? Was that even addressed in those third department cases? Because that's really the issue here.
All right. Well, first let me say this.
Are you going to answer my question about what, if any, you know, did they address that, the interpretation? Because they either addressed it or they did not. Because that's really what's at issue here.
All right. With respect to the issue of the arbitrary and capriciousness of the decision not to take Claudia's case to arbitration, I would say, first of all, on an outside teaching assignment, a teacher takes on an additional risk of travel that a teacher who's at the school all day does not take on. That's why the appellate division carved out those exceptions for teachers who have outside teaching assignments.
And this is the third department, am I correct? You're referring to the third department, am I correct about that?
Correct.
Okay, so since we're on the same page here, my question is, those cases dealt with workers' comp. And I would like to know, what, if any, interpretation did they provide regarding that term on duty? Because that is what is at issue, whether or not she was on duty. And I've looked at those cases, and I don't think they even address that.
Well, they said that was within the course of the teacher's employment, just as the trip to the place of teaching was within the course of employment. The return trip was also. And in this case,
But was that a line of duty injury claim? I'm referring to the workers' comp cases. I don't think so. Were they?
say that again?
Yes. My question is, those third department cases, which I know that you find controlling here, did those involve the interpretation of on duty as they relate to line of duty claims?
I don't see any substantial difference between the claim here that that Claudia was off duty and the claim in Marciniak and Bump that the teachers were off duty. I think in both cases, the respondents were saying teachers were done for the day, you were off duty, and the appellate division has rejected that.
Thank you very much.
Thank you.
Thank you. The next case is Shivers versus City Smiles Dental.
Good
You
afternoon.
actually go in the back, but it's okay. That stays your spot. I'm sorry? It stays her spot.
My spot.
Yeah.
Good afternoon, Your Honors. My name
Else
is
we'll get confused.
My name is Tracy Frankel, and I represent River Bay Corporation and Co-op City Department of Public Safety. I'd like to first start with the 1983 claim and the court's decision based on the title that the corporate defendant gave to its employees, peace officers. Because the court made its decision based on the title of the position of the employee, they applied the criminal code and the criminal procedural law to discuss the scope of a peace officer and determine that they were peace officers. Courts don't base the analysis of whether a party is a state actor under 1983 based on their title. They base it on whether they've been given authority from the state or whether they're acting jointly. And the courts, in various contexts in our jurisprudence, also reject using title as a basis to find liability.
Let me ask you, the burden is on you as the move-in to show that they were not acting under color of law. How, in this case, have you met your burden of showing that the officers were not acting under color of law, considering that they detained her, that they did have a status as peace officer, that they had certain authority in terms of their role, or at least there's disputed issues of fact about that?
Yeah, so it was their job as security for a corporation, for a private corporation.
More than just security, because there's no dispute they were peace officers.
Well,
which
the
gives
title
you a
was
greater
peace
status
officer.
than that of just being a security guard. So
The title that was given was peace officers, but they were acting as security employees of this corporation.
You're saying the label, you're saying your position is the label, we shouldn't be deciding this case, or Supreme Court erred by looking just at the label and going from that point on. The label, it seems, correct me if I'm wrong, that you're saying that the label is a misnomer. It's not really something you can look at, right?
Well, that's right, and what I'm saying is that it's not a peace officer within the context of the criminal law that the court was applying, and the court didn't analyze the definition of peace officer within that context.
I want to focus on my first question, which I maybe didn't give you a chance to answer.
It's okay.
How did you meet your burden of showing that these officers, whatever their title is, were not acting under color of law? Since
Sure.
it was your obligation.
So what What the defendants showed were that they were corporate employees, that they were employed by a corporation, that Officer Boone had testified distinguishing between city employees and what they do in the context of someone who left the employ of River Bay Corporation and went to work for the city. In addition, plaintiff also described the difference between police officers and security, and the plaintiff actually stated that they were security officers for River Bay Corporation. But importantly, the plaintiff never pled that we were operating under color of law. The complaint says that we were a business and a corporation. The complaint says that we were security, and the complaint and the bill of particulars says that we were operating under the scope of our employment. So in connection with what we have to defend, we don't have to defend a color of state law claim when it's not
It's inconsistent to be liable, because obviously it's respondent superior. It's inconsistent to be liable under respondent superior and also be liable under 1983?
Well, there's no claim that there's no claim that they're being that they're being sued under respondent superior.
They were acting, the reason that you would be liable is because they were acting in the scope of their employment. That's why you're ultimately responsible as opposed to just the officers individually, correct?
Well, that's correct, that they were.
So why, I thought you were saying that it's inconsistent to be liable as employees, but also be under color of law.
No, what I'm saying is that the criminal procedure identifies peace officers and what they mean in order to be held liable under the sections that the court was applying. And in those 80 or so definitions of what meets peace officer, ours doesn't. In fact,
Counsel, you are from River Bay?
We are from River Bay and Co-op.
Okay, because how do you address the fact that Officer Boone testified that she was employed by River Bay as a peace officer, and then later on had indicated that, she took the position that plaintiff was not free to leave during the investigation? So how do we reconcile that testimony?
Well, when any security guard, let's say for a retail outfit, is investigating a shoplifter, for example.
Right, that's a private security guard, which is not a peace officer. But these were the words out of her mouth, that she was employed by River Bay as a peace officer. And we know the difference between the two positions, and that certainly plaintiff, of course, was upset, but it was her understanding, I'm referring to Officer Boone, that plaintiff was not free to leave while the investigation was going on.
Right.
This is not a private security person.
My point, Your Honor, is that whether someone is free to leave is a question that would be dealt with in the private security situation, like a shoplifter, as well as any investigation by a police officer. But if you're talking about...
Are you conceding that if they are peace officers under the law, that they would be acting under color of law?
No concessions here, Your Honor. There has to be proof and an allegation that they're operating with state authority, that they're acting under the color of law.
That's why I'm asking that question. There is a city legislation that designates them as peace officers. So if we accept that as correct, that they are peace officers under that city legislation, which is specific to them, then why is that not enough to at least raise an issue of fact as to whether or not they were acting under color of law?
If there's nothing in the record that there is authority from the state, that they can act with the authority of the state.
As opposed to the city?
Either.
Isn't there city legislation? Isn't there a city legislation that makes them peace officers?
Not on this record, Your Honor. There isn't. And there's no allegation under Cebulski. If there's no allegation of it, it can be dismissed on those grounds as well. So it was incumbent, once we, the defendants, made our motion for the plaintiff to raise a question. If Your Honor is pointing to some legislation out there that gives them the color of authority, then it was incumbent upon them to raise it. But they actually never argued it in their opposition as well. So,
No, that was it. That was
Okay.
it.
Okay, thank you very much.
I'll save the rest for rebuttal. Thank you.
Bingo.
Your Honors, good afternoon. I'm Richard Ashnault from the law offices of Kevin P. Westerman, and I'm here for City Smiles Dental and Dr. Sandra Tenzer, and Dr. Tenzer, DBA, City Smiles Dental as well. The first issue here is the contractual indemnity claim. The opinion of the court below was...
We got that part about the opinion says one thing, and the opinion says one thing, but the decreto says another. And let's get to the part where you're arguing the illegal detention claim is still live against your client, correct? Am I mistaken?
That's correct, and I think that is, it should...
And why should that be, dismissed?
Well, Your Honor, there's a couple of reasons. Number one, there's really no evidence that Ms. Shivers ever wanted to leave or was prevented from leaving or anything like that.
Didn't she testify to that, that she felt like she couldn't leave?
I think that her exact words, she felt somewhat detained, or I don't remember the exact words.
Isn't that testimony, in addition to the gate being partially closed, or an allegation that the gate was partially closed, enough to at least raise factual issues as to the forcible detention?
I don't believe so, Your Honor, because first of all, there was another exit which she could have left through. The City Smiles employees indicated that if she had wanted to leave, she would have been allowed to do so.
But isn't that just, aren't those all issues of fact, how each person was perceiving a situation which was obviously somewhat heated and unusual, and each person was taking a different feeling about the situation? If she had any belief that she didn't feel like she could leave, isn't that enough to raise an issue of fact in these circumstances?
Potentially. There's also the question of whether or not the detention itself was illegal or wrongful in any way, which raises the issue of whether there was probable cause to question her or investigate her.
Isn't that inherently a factual situation also under the circumstances?
Well, there's no factual issue as to the fact that
It's a fact that someone in the office could not find their phone. That's really all we have. Is that enough to create probable cause, undisputed, that she was potentially responsible for taking it?
There's also the question of the tracking device that was being used to track the iPhone that was missing.
That she was not at ShopRite, so doesn't that again create a factual issue?
Well, Your Honor, the phone mysteriously appeared back when she returned to the office, and it also was found.
Wait a second, hold on. Correct me if I'm wrong. The facts are she saw the dentist, she was finished, her husband was next, she had left the premises and came back. And that's when on her return to come pick up her husband, that's when the whole, scenario occurred, right? Where the cell phone went missing and...
No, the cell phone was determined to be missing while she was outside the store.
That's what I'm saying, right. So when she came back, then that's when, the accusations started to fly, right? She had left and she came back, but in that meantime, that's when the phone disappeared, or allegedly disappeared, because they found the phone ultimately.
They found it after she had returned, and they found that it had returned to the office when Ms. Shivers returned to the office as well, based on the tracking device that they were following.
So maybe she took the phone and brought it back and secreted it in the drawer, or maybe she didn't take it at all and it was in the drawer the whole time. And who are we to opine on which of those two factual scenarios in fact occurred?
Well, the question remains then, was any detention that occurred, however brief it was, 20 minutes or whatever, while they investigated whether or not she did have the phone, was that wrongful in any way.
That's a
And,
factual issue. You just teed it up right there for the jury to try to figure out that out.
Well, but we still have the undisputed evidence of the tracking device that followed Ms. Shivers.
No, that tracking.
I'm not sure, yeah, I'm sorry, please.
You go. We're going to say why.
Yeah, because, you know, plaintiff said that she was at the Dollar Tree. The tracking device didn't even really say it was at the Rite Aid, in the vicinity of the Rite Aid. And if I'm not mistaken, and I don't mind if you correct me, I don't, from what I recall, that, I forgot the person's name now, but they didn't go back and verify, oh yes, this is where it was. So you have a lot of questions here. You have a lot of holes here.
Well, but if there are questions, one thing that is not questioned is that the phone is now based on the tracking device back in the office at the time Ms. Shivers is.
And it was also in the vicinity. It was the vicinity, not the exact location.
The testimony was actually that it was showing right next to where Ms. Shivers was sitting in the reception room after she had returned.
These wonderful evidence issues in this new brave new world, right? Because we have testimony regarding what the tracking device reflected, right? We don't have some printout or some documentation of what in fact, or screenshot of what the tracking device depicted. We have testimony about what was depicted on the tracking device.
Unfortunately, we do not have that. You're correct.
Thank you very much.
Thank you.
Good afternoon, may it please the court. I'm Annette Hassapidis, appearing for the plaintiff. I'd like to begin first with River
I'm
Bay's.
actually going to ask you to focus on the color of law argument.
Thank you, Your Honor.
Is that
The
what you
River
were
Bay
planning to
argument.
talk about?
Yes.
What in this case, obviously we're employees of Co-op City. They're not literally state employees. So what brings them under color of law?
What brings them under color of law
1983?
is the testimony of Officer Boone at page 272, Your Honor. Officer Boone at 272.
Well, whatever testimony.
Well,
I just wanted to hear the answer.
no, Officer Boone testified that she is a peace officer, that she performs arrests, and that she is armed. The
Okay, so
judge did not.
Where is the cases that talk about, if she is a peace officer, where are the cases that talk about whether a peace officer is acting under, why does that as a matter of law establish, or why does that establish that she's acting under color of law?
Well, their argument below, at page 35, was that there was no evidence that they were acting under color of state law. That was not a proffer in the first instance. They never met their burden of proof in the first instance, at page 35 of the record.
Your 1983 claim, so they did the burden because we're moving for summary judgment, but you're making the claim that this is a 1983 action. To make that claim, they have to be under the law, acting under color of state law. So how are you saying that it's the fact that they have a designation of peace officer, which seems to be somewhat disputed, but if they have the designation of peace officer and they carry a gun and they can make arrests, that makes them acting under color of law?
Yes, Your Honor. And the court did not fail to engage in an analysis of whether they fell within the definition of peace officers. The judge at page 12 of the decision said they've conceded the issue. They've admitted throughout that they are peace officers.
Yeah, but counsel, that's exactly what I want to ask you. My question is that you're basing your peace officer definition to the fact that the testimony where the officer testified that these are her duties.
Yeah.
Just by the fact that the individual is testifying doesn't raise, I'm trying to understand, does that automatically raise it to a level of being a state actor because the individual themselves or him or herself is testifying to that?
No.
I mean, you can't, right? I mean, you can't just
You're
say,
correct, Your Honor, and the
right?
lower court reached the same conclusion. The lower court said there are questions of fact based on the admissions of Peace Officer Boone that she was a peace officer who was armed and performed arrests.
Let's just say,
let's
just say to me, there is no factual issue. Because she made that testimony, she is, by all means, a peace officer. But if she doesn't fall into the categories, this public officers law, there are 84 categories of who are peace officers. Because you fall into any one of those 84 categories, you're automatically a state actor.
That's
River Bay is not one of the 84, and the only link you got is the city council legislation that elevated them to peace officer status, right?
Yes, yes.
Council was saying, well, that's a city administrative code. That conflicts with the state law that says only these 84 categories are peace officers.
Well, we argued below, and we submit to the court that they fall within one of the 84 categories of peace officers, and that there are at least questions of fact there based on
I looked at
testimony
those
that was
84
proffered.
categories, and they were very clear. It's like they got Syracuse, they got Rochester, they got XYZ, they got court clerks.
I appreciate your point, Judge Owen.
I couldn't find River Bay.
I appreciate that. I'd
Before
like
your
to.
time expires, would you address the probable cause argument?
I would like to. I see my time is just about up, so I'd like to be able to address that. My client never felt that she was free to leave. In that regard, I'd refer the court to page 84 and page 1.
Wasn't that forcible detention? You were asking about probable cause.
Illegal, I'm sorry, Your Honor. You're
Right, the
I
probable
apologize.
cause.
Yes, okay. So there's been all this talking about tracking, and Judge Higgett, you even referred to the fact that in this day of technology, we don't have the data from this phone. The officer came to the premises and was told, we've tracked this stolen phone and we think she took it. The officer doesn't ask to see the phone. The officer doesn't ask to look at the tracking on the phone. The officer essentially detains my client and says, stand right here, it'll all be over in a little while. The officer didn't have the authority to do that without looking at the tracking devices and just accepting what other people said had occurred. There was no explanation ever given in the statements offered by Ms. Abdul or Ms. Teal why the officer was not shown the phone, and that's why we don't have that data here.
What about as to the probable cause on the City Smiles defendants?
The city smiles the same reasoning really, because they admitted in their testimony, Ms. Abdul admitted that the tracking did not ping correctly. She, at pages 400 and 412, there was testimony that the tracking device was pinging between the Rite Aid and the parking lot. Ms. Abdul went into the Rite Aid, did not see my client there. Then she comes back to the office, and there are 5 to 7 people in the waiting room. And Ms. Abdul says that the pinging was in the waiting room, not on my client. Ms. Teal said something different. So they still didn't have a strong enough basis to simply decide to hold my client to the exclusion of everybody else in the waiting room. They hadn't seen her in Rite Aid.
Thank you. Are there any more questions? Okay, thank you very much.
Thank you.
Very quickly before I skip to the contractual indemnity granting.
Let me ask you about because we never got to ask the opposing. Are there any contracts in this case? Is there any contract that exists between the two defendants?
So actually, the movement put in its motion as an exhibit Dr. Tenzer's testimony, which admitted to the existence of the lease, admitted that the lease included a requirement to procure insurance and add as an additional insured our clients.
Was the lease admitted into evidence?
There was a lease admitted into the lease was used in the deposition. It was authenticated at the deposition, and it was admitted to at the deposition, which should have, in and of itself, raised a question of fact.
We don't need the lease? If you want to make a contractual indemnification claim, we don't need to actually see a copy of the lease to support it?
I would
We can rely on
submit,
the testimony?
I would submit that it is, given the admissions, it was the movement's duty in its moving papers
If you're
to
moving for
submit it.
contractual indemnification, you don't have to submit the document that you claim creates the contractual indemnity obligation?
We were a respondent, let's say, to that motion. We're not the movement, so the burden is on the movement. You can't win on summary judgment if you omit material evidence. But their testimony and admission of the existence and the procurement of insurance requirement, which was a cross-claim by us, raised its own. question of fact. They failed to eliminate that question of fact in their moving papers, and that meant, Your Honor, that we didn't have to raise a question of fact, we didn't have to oppose the motion, and their motion papers didn't actually address any of the arguments on the cross motion.
Thank you.
If I may be permitted to...
No, your time's up. Thank you.
Thank you.
With regard to the contractual indemnity issue,
Say, why don't you address the contractual indemnity?
I thought you might be asking me that. Yeah, the lease was not part of the record below. There was no evidence.
River Bay cross-move for summary, my notes here indicate that River Bay defending you're not defending River Bay, right?
No, I'm not.
Okay, so my notes indicate that they moved to dismiss summary judgment-wise your cross-claims against them. That would include the contractual indemnification, right? So, my notes
No,
wrong?
no. We moved to dismiss their contractual indemnification claims against us.
Oh, they didn't, okay, there was no, okay.
They moved to dismiss our cross-claims as well.
Okay.
And the lease was not before the court below at all. It was not submitted as an exhibit to any of the motions.
Right, you just said that they moved to dismiss your cross-claims too. You're both moving to dismiss each other's cross-claims.
Correct.
Okay.
All right, and with regard to the common law indemnity,
I'm a little mystified by that because you only get common law indemnity if you can show that you were held vicariously liable, as a result of which you get to pass it on to someone else. But that's not the basis of liability for either of the defendants in this action. Neither of you are being brought into this case based on your vicarious liability. So doesn't any common law indemnification claim fail as a matter of law?
well, that was our argument, our common law, we moved to
Both
dismiss.
should be dismissed then,
We
right?
moved, I would agree with that, yes.
Okay. Great. Any other questions?
No, that's all
Okay.
for me. Thank you,
Thank you
Your
very
Honor.
much. The next case is People versus Bracero.
Good afternoon. May it please the court. Nicole Giuglas on behalf of appellant Alex Bracero.
Welcome back.
Factor 4 applies only where there is clear and convincing evidence of both sexual contact on multiple occasions and contact that occurs over the course of a specified period of time. Here, because there was no proof as to the second factor, the timing of the sexual contact at issue, the SORA court erred in assessing factor 4 points against Mr. Bracero. Despite its somewhat misleading name, continuing course of sexual misconduct, the board has been clear that factor 4 captures only repeated instances of sexual contact. There must be either 2 or more instances separated in time by 24 hours, in which case at least one of them must be either intercourse or aggravated sexual contact, or 3 or more acts over the period of at least 2 weeks. Neither was proven by clear and convincing evidence here. The parties agree that there is sufficient proof of more than one instance.
Counsel, I'm looking at the record. I'm not sure what the basis for your argument is, because there was grand jury testimony, which does seem to support that there was sex on his birthday and then on the subsequent 3-day stay, which would fit within that definition of factor 4. Why is that not sufficient?
The complainant did not testify in the grand jury to there being contact on his birthday and subsequently contact. There was no delineation within the complainant's grand jury testimony that made clear that those were 2 separate instances separated in time. At all times.
Did she talk about the birthday and then she talked about having to stay there when she had nowhere else to stay?
But she didn't, she never, at no point was she asked or did she testify, and it was not necessary or related to any of the charges, that those were separate occasions. She was testifying about her interactions with Mr. Bracero in the month of February 2017. There was no testimony that she had this encounter around his birthday, and then there was a later, separated by time instance that she went to his apartment for 3 days. The way that the record appears, it's just as likely that the beginning, perhaps, of the 3-day occasion that she stayed with Mr. Bracero was on or around his birthday.
Were there other incidents in terms of him arranging sexual encounters with other individuals that maybe could weigh into factor 4?
No, for 2 reasons. One, there is not any evidence in the record as to actual sexual contact with any customers, what it may have entailed, or timing as to them. And 2, Mr. Bracero would not be liable as an accessory for those encounters if there were evidence of them having occurred, because he does not have a shared intent with the customers, which would have needed to be proven for factor 4 to apply against him. Because he doesn't have accessory liability, and because the record is not clear, for example, in other cases in the 3rd Department, there was similar information in that there were multiple instances of sexual contact over the course of a month, but there was no information as to the relative timing, and that was insufficient for factor 4.
Thank you.
Good afternoon, Your Honors. May it please the Court, Assistant District Attorney Saad Siddiqui on behalf of the people of the State of New York, Bronx County District Attorney's Office. Your Honor, I would note at the, Your Honors, excuse me, I would note at the onset that the people have maintained that the defendant appellant was correctly assessed to be a level 2 sex offender. With respect to the points raised by counsel, I would note that there were 3 instances of sexual contact between the defendant appellate and the victim in this case. There was the February 16th incident in which the appellant did rape the victim. There were also 2 separate incidents which were testified to with respect to the 3-day stay.
But was there any delineation as to the timing? Were they all 3 incidents within 24 hours or outside of that?
Well, Your Honor, I would note—
Or can it be inferred?
I think it can reasonably be inferred based on the evidence adduced at the hearing and at the grand jury. The SORA court made that determination looking at the totality of the factors, or the facts presented. We know that the defendant appellant first met this victim when she had come to the multifamily dwelling to get a tattoo from the appellant's cousin. Subsequent to that, the defendant appellant then initiated contact via social media, Facebook Messenger, with the victim, brought her to the apartment, took pictures. Then the co-defendant, the appellant's girlfriend, who had the name Diamond, initiated contact with the victim to engage her in sexual acts on his birthday. Subsequent to that, based on the way the testimony was adduced at the grand jury, there was the incident in which the victim, testified that she awoke to the defendant appellant inside of her and the co-defendant present in the room. Then there was another instance in which the defendant appellant purportedly said, "You know what time it is," and then demanded sex from her then and there. And she testified that she took off her pants and had sex with him. Those were 3 separate acts of rape. Independent of that, there was testimony presented by the victim that during the 3-day stay and beyond, she engaged in acts of prostitution at the behest of the appellant. He arranged, quote unquote, dates for her through social media, both at the apartment on Webster Avenue where the appellant was residing and at a hotel on White Plains Road. 2 separate locations, and she testified that those dates were sexual acts, and what was very clear with the testimony presented at the grand jury, the defendant appellant was present when this occurred. He was in the bathroom when the date came there. She took the money, presented it to the dependent appellant, Having said that, it's very clear, based on the totality of the facts, that the defendant also shared the intent of the clients. He trafficked this victim. Based on the court's own holding in People v. Johnson, it's very clear he shared that intent. He was looking to traffic her. He engaged in sexual acts with her, and then was looking to continue to prostitute her even beyond March 2017, when in December of 2017, he reinitiated contact and even attempted to renegotiate the financial terms and said, I'll offer you a 60-40 split. And during those instances where he thought he was communicating with the victim, he was in fact communicating with Detective Byrne from the NYPD, he was telling her that he wanted to also continue to have sex with her repeatedly between December of 2017 up until February of 2018, when he attempted to have her meet him in Staten Island, where he was residing at the time. Not only so, Detective Byrne told the defendant appellant that the victim was 16, and that she still, an emphasis on this word, still had an ACS case. So the not so subtle inference there is that the defendant appellant was always cognizant of the victim's age, her issues with ACS. I mean, this was predatory from beginning to end, the conduct of the appellant. And I would note that irrespective of our position that he was correctly assessed a level 2 sex offender and was appropriately ascribed those points, if the court were to side with the appellant that he was given those points erroneously, he still warrants being held to be a level 2 sex offender by virtue of the egregious nature of this conduct.
Thank you very much.
Thank you, Your Honor.
Because factor 4 is limited to sexual contact, the allegations related to communications with Detective Byrne are irrelevant to that analysis. The people also failed to preserve any request for an upward departure should the points be reversed as is appropriate. Throughout her testimony, the complainant testified that she had multiple sexual encounters with Mr. Bracero in the month of February 2017. She did not testify, and she was not asked, the relative timing of those events. Because that evidence is not in the record and is not proven by clear and convincing evidence, factor 4 points are inappropriate, and they should be reversed.
Thank you very much. The next and last case on the calendar is Hutcher versus Madison Square Garden.
May it please the court, my name is Randy Mastro from King and Spalding, representing the defendants' appellants, Madison Square Garden. Your Honors, this is an appeal from an unprecedented preliminary injunction that cannot stand for several independent reasons. First and foremost, it is predicated solely on a misreading of an ancient civil rights statute that hasn't been applied in this manner in over 80 years.
Well, is
Second,
it the statute that's at issue or the case that was decided, Wilcott versus, isn't that what's determining how this was decided? I'm sorry, isn't Wilcott the issue?
Wilcott is very much in our favor, Your Honor.
Right,
Yes.
yes.
This has actually been the law in New York for over 100 years under this civil rights statute. It's a misreading of 40B. it's also a misreading of the statute in terms of it provides a specific remedy, doesn't include an injunction, and that's under Wolcott, Madden, and Sins exclusive.
I think I was confused, because it's not really the statute. It's whether, because the statute is silent about injunctive relief and it only grants you money damages, does the court have the authority then to grant injunctive relief when the statute is silent? It doesn't say one way or another whether injunctive relief is appropriate.
And it does not have that.
Why can the court not use its inherent authority, which it always has to grant injunctive relief, to allow it even where the statute did not otherwise provide for injunctive relief?
Well, because, Your Honor, going back to Wolcott, but in the years since, Drinkhouse and otherwise, it is the law in this state that when there is an exception created by statute to longstanding common law, that exception not only has to be strictly and narrowly construed, but where that exception provides a remedy. That is the exclusive remedy. That is what Wolcott says, that is what Madden says about this very statute, and it's what Drinkhouse has said more recently, where the Court of Appeals said, quote, where a new right is created by statute, if a remedy be given by the same statute for its violation or non-performance, the remedy given is exclusive.
And how does that interplay with the general power of the courts to grant injunctive relief where it's appropriate, and the argument made that money damages really are not an adequate remedy under the circumstances of this particular case?
Well, Your Honor, the interplay is that the courts are not granted under that statute the ability to grant injunctions for the following reason. The common law for over 100 years in this state has been that there is the absolute authority of the private entertainment venue operator to decide who can and can't use their property. That is absolute. When a statute creates a limited exception, as was the case here back in 1940 under the Civil Rights Law, Section 40B, where the statute then says what the remedy is for that limited exception to the longstanding common law. It is the rule in New York going back over 100 years to Wolcott that the statutory remedy is exclusive because there would be no ability, no claim would exist under the common law, no ability to have an injunction. So, Your Honor, I think that that's about as crystal clear as you could be going back over 100 years, but reaffirmed in Drinkhouse more recently that limited statutory exception to the common law, where you have an absolute common law right as a private venue operator, the limited exception providing the exclusive remedy, because otherwise there's no violation under the common law for which a remedy could even be considered. So I think that that is so crystal clear, Your Honor, that on that basis alone, this injunction could not stand. But there's more, because there is a fundamental misreading of 40B here. It would, in particular contexts, at particular venues specified in 40B, it would eviscerate the rights of the private property owner that have existed for over 100 years under New York's common law. And the same principles that Your Honor just referred us to apply to how you interpret the statute. Because the New York Court of Appeals and this court has repeatedly told litigants that where you have an exception being created by statute to the common law, it has to be narrowly construed.
What about the unique circumstances of this case where people are being denied entry to an event because they've brought litigation against a defendant, whether that is an appropriate use under a public policy to allow that to occur?
Now, Your Honor.
The legislature's already said that's not allowed and that we're going to grant a monetary remedy. Why can't a court say, based on these particular circumstances, where you're chilling litigation and lawyers from doing what lawyers are supposed to do, that's just not appropriate under the circumstances, and equity should intervene?
Okay. So, Your Honor, I'm glad you asked that question, because the fact of the matter is, it doesn't matter whether this is a popular policy. It doesn't matter whether it is a rational policy from the court's perspective. 40B doesn't actually do what Your Honor just posited is the circumstance here. 40B on its face applies only to specific venues, and it only applies to, as even the lower court recognized in denying a TRO initially, it only applies to the limited circumstance of a revocation that occurs at the door. Here, the legislature didn't do anything back in 1940 under CRLO Section 40B to affect in any way, shape, or form the rights of a private property owner to decide he doesn't like people with green eyes, he doesn't like people with long hair, he doesn't like lawyers who sue him to come to his venues. The legislature said only limited to revoking at the door, and the statute was challenged on constitutional grounds at the time in Christie, and the basis on which, the limited basis on which the court found it was constitutional was that there was no reason assigned at the door. Here, the exact opposite. There was no limitation under CLR 40B to Madison Square Garden's right to have venue policies that exclude people. In fact, if we didn't have the right to exclude people, you could have the terrible circumstance where people who commit acts of violence at the venue and are then banned could go around to the internet and get tickets.
Counsel, let me ask one question, just in terms of, I'm just asking the definition for the place of public entertainment and amusement. And they have a list that doesn't necessarily include sporting venues of that nature. Does it matter that Madison Square Garden has multiple purposes?
It doesn't, Your Honor, because the statute has to be strictly construed, and it says nothing about the rights of Madison Square Garden to revoke in advance the right of someone to come. This is not a circumstance where someone shows up at the door in good faith, where they acquired a ticket from the venue, and then they are denied for no reason. It's a circumstance where in advance, the parties know, because they've gotten written notice of the policy that they will not be admitted. Then they got a second notice saying in advance, any tickets you acquire through third parties, the internet, that didn't exist back in 1940. Most tickets today are not sold directly by the venue.
Thank you. You're going to have a chance in rebuttal to get into this.
Yes.
I gave you a lot of time today. Thank you.
Okay, I appreciate it, Your Honor, but it was revoked in advance, and the statute says nothing to the
you.
contrary in that regard.
Good afternoon, Your Honors. I'm Larry Hutcher, and I am banned from Madison Square Garden. And that is very disturbing to me. And I believe that Section 40B of the Civil Rights Law not only affords me the right to go to the non-sporting events that Judge Lyle Frank found below, but as the judge said, to the world's most famous arena. That's what Madison Square Garden builds it at. It doesn't
Right,
say...
but don't we have to look at the language of the statute in terms of the scope of what the statute does or does not encompass?
Absolutely, Your Honor, and the statute clearly describes venues. It doesn't describe performances at all. And the significant thing is Judge Frank, in his decision, referred to the type of performance. There is no reference in the statute to performance. It refers to venues. And that is significant because once you find that Madison Square Garden is a venue that falls within 40B, which it clearly is because it holds concerts, it holds all sorts of events, then the parsing of what type of event comes in there is not part of the statute. So I believe you do need to rely upon the statute, and it talks about a venue. It doesn't talk about a performance. But I think it's important that counsel's reliance on Wolcott was decided in 1907. The civil rights law...
Walcott's still good law, though, in terms of, because the principle it states appears to still be the current state of the law, that if a statute provides for specific remedy, the court should not impose a remedy not provided for.
Okay, let's first talk...
And then it's an abrogation of the common law. If it's not an abrogation of the common law, then it's a different story.
Yeah, I wasn't talking about that part, Your Honor. First, I was talking about the abrogation of a venue owner's right to
No, I know,
control.
but now we're going into the injunction, I assume.
Yes, so And we've cited cases, and particularly Bennett versus Laitman, which is a Court of Appeals case, which says clearly, if the interest sought to be protected is one of which equity will take cognizance, it will not refuse to take jurisdiction on the ground that the act which invades the interest is punishable by the penal statutes of the state. Courts always have.
Isn't that a different situation than what we're talking about here?
Absolutely not.
Where there was no right under the common law, the right was created under the statute, which is a different situation than what you just described.
No, but Your Honor, it is a situation where a court, and it is a case we cite where there was a chiropractor that under their statute, all they could do was issue a fine. It was a new statute, it created a right.
But it wasn't a derogation of the common law.
Oh, sure it was, because there was no reference to chiropractors in the common law. It created saying if you practice chiropractic without a license, you are going to be fined. And so the court looked at it and said, and the argument was the exact same argument Mr. Mastro makes. You can't issue an injunction against me because the statute doesn't authorize that. Here, it's the same situation.
Yeah, but that's a slightly different situation. Chiropractors, they practice medicine. I mean, we're talking about, there's a little bit of an edge there, right? I mean, right? I mean, you want to enjoin someone who shouldn't be practicing as medical arts, right?
I will submit to you that an attempt, which is clearly an attempt to chill attorneys from doing their job and literally advocating on behalf of clients. I had New York Knicks season tickets for 47 years. I sued once.
And now they're on the upswing, too.
And you're telling me, Judge, I had to go to Miami to see them. But the point is, that is the same type of public interest that applies to this situation that applied in any of those situations. The argument that 40B doesn't apply is absurd.
But, sir, I think the problem, and I'm sorry if I'm covering ground Judge Kern previously covered, the common law prior to this statute provided a venue operator to exclude any and all.
Correct.
Save perhaps for some discriminatory type reasons. The legislature intervenes as reflected in 40-B. They then reference in section 41 the penalties, which are particular fines, not less than a certain amount, not more than a certain amount, and it also represents, I think, an A misdemeanor. Why should you get more than what the legislature provided when it acted, which was its right in derogation of the common law?
Because I don't believe the legislature intended to limit the type of relief that a court, in the exercise of its equitable discretion, could exercise, could say, we as judges have the ability to fashion a remedy when we don't believe one exists under the law. That's what Bennett stands for. There are tons of cases, and we've cited them in our brief, where that standard principle, we can frame and create a remedy to address this type of wrong. This is a vindictive act against attorneys. All we're saying is that that should not be continued to be enforced.
Can we talk about for a second?
40B. That's not expanding anything. That's basically saying, be responsible and uphold the law.
Can we talk for a second about the workability of the preliminary injunction?
I'm sorry?
The workability of the preliminary injunction?
Is there Your Honor, there was an attempt to limit the injunction in December. That application was denied twice, once originally by Judge Gish and second by the panel. The garden has been open since then. There are no issues. There is no limitation on Madison Square Garden's ability to identify terrorists and exclude people. And most importantly, this injunction applies to 60 lawyers in my firm. Unbeknownst to me, there may be some terrorists, but I don't think so. There's no violent felons. There is no risk that if we were permitted to go back to the garden and see the Knicks, I hope, not the Rangers, just the Knicks, and we're not disturbing the peace. There's no limitation on their ability. This is all an attempt to continue to chill and affect lawyers.
Thank you. Are there any more questions from the bench? Thank you.
Your Honor asked about the public policy implications, and Mr. Hutcher brought them up. Your Honor, the public policy implications here are even more problematic in terms of the rights of private property owners. Just a year and a half ago, the Supreme Court in the Cedar Point nursery case ruled that, quote, "the right to exclude is one of the most treasured rights of private property ownership." And Your Honor, I hear Mr. Hutcher say that this is some attempt to chill lawyers in their advocacy, and lawyers will be chilled in their advocacy. I have to say, you'll forgive me for saying this, but to me, that's an insult to lawyers who do what we do. Mr. Hutcher hasn't been chilled in his advocacy. I've had death threats from cases that I brought. I had my home defaced and destroyed.
Well, counsel, let's just talk about that. Underneath our rules of professional responsibility, we already have vehicles in place. If in fact these lawyers were to go to Madison Square Garden and join a sporting event and maybe step outside of that and it somehow impacted the case, we already have vehicles and remedies for that. So why this policy targeted specifically at these particular lawyers?
Yes, because, Your Honor, just like in other walks of life, okay, a private property owner has a right to say, I don't want you coming onto my property, and I don't want to do business with people who sue me. Just like co-op boards have turned me down because I'm a litigious lawyer, and they don't want me to be in their building, and I can't do anything about that. This is not about chilling lawyers in their respective rights, but it is about what rights one has under that particular statute.
What do you have to say
compared
about
the common law?
What do you say about his example about the chiropractor? How the law there didn't provide for an injunction and you get the injunction?
But, Your Honor, as was rightly pointed out, it is a different context. And there wasn't a long history of common law protection of over 100 years where a narrow carve-out is made by statute. And I have to add this. In addition to the Wolcott Drink House line of cases for the past 100 years that say that when you have a statutory carve-out of the longstanding common law, that you can only apply the remedy that's provided in the statute. It's also a standard rule of statutory construction for over 100 years.
Thank you, counsel.
That you read it in conjunction with other provisions, and they don't allow.
Thank you, counsel. Thank you.
No problem. Thank you, Your Honor. I really appreciate
You are
it.
litigious, don't you?
Thank you. Thank you. I'm a zealous advocate. I'm sorry, Your Honor. It's a very important case, as they all are. Thank you.
I just have one real quick statement. I would just hope the court, when it looks at the decision, it will see that Judge Frank's reference to performances was a mistake. I believe that it is clear and indisputable that Madison Square Garden falls within the purview of 40B, and it should be for all purposes. I thank you for your time, Your Honors.
Thank you.